Okay, we're back after this discussion of Lochner versus New York to talk about Mueller versus Oregon and West Coast Hotel versus Parrish. So up until this point, we've looked at two cases. One involved a state interfering in private contracts to stop fraud. And the Supreme Court upholds that effort in Munn versus Illinois. On the other hand, the Supreme Court strikes down a New York law that interfered in private labor contracts, something that the court did not smile on very much. There was no fraud involved, according to the court. There was just an effort here to interfere in contracts in a way that disadvantaged one party, and the court saw that one party being disadvantaged as labor, not the company owners. And so it strikes down the act. Well, now in this third section, we come to another type of state regulation that the court, up until this point, has held to be even worse. And that is even worse than interfering in private labor contracts in terms of working hours and working conditions. When we get to West Coast Hotel v. Parrish, we're talking about minimum wage laws. But first, let's talk about Mueller versus Oregon. Now, in Mueller, the state of Oregon attempted to fix working hours and working conditions for maids for a particular segment of the labor market. And the Supreme Court upheld this. So it looks like, actually, like 3 years after Lochner, the court changes its mind in some ways to allow for working hours and a state regulation of working hours. And the court says, while the general right to contract is protected by the 14th Amendment, liberty is not absolute. A state may, without conflicting with the provisions of this amendment, restrict in many respects, the individual's power of contract. So one of the reasons why the court did this and sided with the state of Oregon in fixing working hours was because it was presented with a brief that showed it the effects of long working hours on public health, in particular on female employees. This brief was called the Brandeis Brief, and that brief went about showing how, according to the best science of the day, women were the weaker sex, that maids in the service industry often had to work while they were pregnant, that a pregnant woman being on her feet all day long destroyed her health and contributed to malnourishment of the unborn child and to death in childbirth. We know now that none of that is true. We've got better science. We actually know that women in the last trimester of pregnancy and immediately after birth are at their physically at their strongest. But at the time, this is what the court was presented with. They were presented with data that they didn't receive when considering the Bake Shop Act in Lochner versus New York. And so the court upholds this law as a legitimate use of the police power to protect public health. Well, that brings us to Atkins Children's Hospital in 1923. Now, this was a case involving the District of Columbia. So we're kind of back to talking about federal power, but not really, because we're talking about its supervision of the District of Columbia. It's sort of in a blind spot here. I'll read from the text here. It says, in 1918, Congress, with the support of the progressive-minded President Woodrow Wilson, enacted a law that fixed minimum wages for women and children in the District of Columbia. The act authorized the establishment of the Minimum Wage Board to set pay rates. The board, staffed by progressives, ordered that restaurants and hospitals pay women workers a minimum wage of 34.5 cents per hour, $16.50 per week, or $71.50 per month. All right, so for the first time, the court is considering, or for one of the first times, the court is considering not an act to stop fraud by setting rates or setting the terms under which people contract, and not a case that sets working hours and regulates working hours and working conditions, but a case that establishes a minimum wage. This is qualitatively different from other sorts of regulations. The others regulate the terms under which contracts occur, and this one, it takes property from A and gives it to B. Right? It takes money from an employer and gives it to an employee. Why should the employer, according to the Supreme Court, why should an employer pay a woman employee 34.5 cents per hour when he can hire an employee for 30 cents an hour? It's taking money from the employer and giving it to the employee. At least that's the way the court views it. And the court considers this question: may the government impose minimum wage requirements for not generally, not a law of general applicability, but for a segment of the workforce, women and children? The court strikes down the regulation. And Justice Sutherland writes a majority opinion, and once again, we get a vicious dissent from Justice Holmes, who states that Congress can establish minimum rates of wages for women with due provision for specific circumstances, and that Congress can interfere in those contracts for the public health, safety, and welfare in the District of Columbia. Here was the reasoning of the majority. The right to contract about one's affairs is a part of liberty, but there is no such thing as an absolute freedom to contract. However, restraint on the right is the exception and not the rule. So what the court is saying there is that both women and children, laborers, and owners of businesses have the right to contract with each other to negotiate for the best possible terms they can get. And Congress, by setting a minimum wage law in the District of Columbia, is interfering in that market. Now, once again, there's the assumption that women and children laborers have precisely the same power as employers in the marketplace. This is an assumption that begins to fall apart over time, and eventually no one buys it anymore. The wealth and power have been so distributed, so widely distributed toward, or so broadly distributed toward a narrow segment of society, what today we might call the 1%, that about the time of the Great Depression, the average person in the United States doesn't trust corporations, doesn't trust the rich, and doesn't buy any of these assumptions anymore about the way the market and the economy works. But the Supreme Court, as we see, is lagging behind. Well, the Supreme Court overturns Adkins versus Children's Hospital in our very last case, West Coast Hotel versus Parrish. This is the one that we referenced in an earlier lecture, in which the Supreme Court begins to change its view of government regulation of the economy. It precedes NLRB v. Jones and Laughlin Steel. And in this case, the Supreme Court upholds a minimum wage law passed by a state. Now, I wanted to show you this image here. This is a postcard that a very close friend of mine bought for me and gave me for my birthday. It is a postcard of the Cascadian Hotel in Wenatchee, Washington. It is the hotel at which Elsie Parrish worked as a maid. And the state of Washington passed this law that required that employers, hotel owners who employed maids, pay them a certain amount of money minimum wage, and then also pay them overtime, time and a half when they work overtime, and then made the law retroactive so that maids could ask for money for time worked in the previous year. Elsie Parrish looked back at her timesheets and said, these people, owners of the Cascadian Hotel, the West Coast Hotel Company, owe me money. And she asked for it, and they refused to pay her. So she filed a grievance before the Employment Board in the state of Washington. The Employment Board ordered West Coast Hotel to pay her her money under this act, and also fined them. So they filed suit, and the case became West Coast Hotel v. Parrish. You'll notice that West Coast Hotel is the petitioner here, so they lost in the court below. The question was, does a state minimum wage law violate the Constitution? This is exactly the question at issue in Adkins versus Children's Hospital. Of course, that case involved Congress and not a state. The court says no, the state does not violate the Constitution when it imposes a minimum wage law. And Justice Hughes writes the majority opinion in our case, Chief Justice Hughes. He says, in dealing with the relation of the employer and the employed, the state legislature has a wide discretion in order that there may be suitable protection of health and safety. Now, this was something that the court up until this point was unwilling to do. It was unwilling to view minimum wage laws as health and safety regulations as part of the police powers, legitimate uses of the police powers. But in West Coast Hotel, we see a change there, and the court upholds what it thought was the worst part of state regulation, and it justifies them under government neutrality and the police powers. This leads us directly to NLRB v. Jones and Laughlin Steele, and what we see is a complete change from what I said in the very first lecture on substantive due process. We see a complete change. Now, virtually everything, local and interstate included, that substantively affects commerce, Congress can regulate, and for those things that are intrastate, state regulation can be justified as health and safety regulations. It's a complete change from earlier. All right, well, thank you very much for your attention. That's substantive due process.